leading that portion? Okay.
The new guy.
Nice to meet you.
Nice to meet you.
All right, guys, it's 1:30.
All right,
Today's meeting of the Municipal Code Enforcement Board is called to order on January 25th, 2023. Welcome, everyone. Please rise for the Pledge of Allegiance. Pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Agendas of today's meeting are on the wall at the entrance to the chambers. Please remember to turn your cell phones off. The Municipal Code Enforcement Board consists of 7 members who are appointed by the City Council. We serve voluntarily. It is this board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method of enforcing certain codes within the city. The board considers new business items in 2 parts. First, the violation, and then affirmative relief. Formal rules of evidence do not apply. Each side is limited to 15 minutes. The board may grant additional time. All proceedings will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, they will be escorted from the chambers. Now I ask all who plan to speak to please rise and be sworn in by the clerk.
Do you swear or affirm to tell the truth throughout your entire testimony?
I do.
Thank you.
Our first order of business is to review and approve the minutes of last month's meeting. May I have a motion to approve the minutes?
I'll make that motion to approve the minutes.
I'll second.
All in favor?
Aye.
Aye. Minutes are approved. And is there anyone here today to speak to items not on the agenda? Hello. Please come to the podium. State your name and address for the record.
Good afternoon. I'm Bill Johnson, 2694 Redford Court West in the countryside area. A couple meetings ago, I brought some photographs and showed what difference can happen when code enforcement works and it converts from someplace that looks really pretty ugly to something that is an asset to the community and the surrounding neighborhood. I brought some more photos, this time to illustrate what happens to some of the properties when code enforcement just goes on and on and on and doesn't resolve the issue. And these are of 1000 Grantwood Avenue. It's in the Wood Valley subdivision down near Moccasin Lake Park. The lien was originally recorded after you took action on it in November of 2019. And I got a copy of the lien report from Nicole and kind of looked at some of the big ones and was looking for examples that would help me understand how the process works and why maybe when it doesn't work. So the property is this one. Is that in the middle? I'm not sure. Okay. And if you zoom in a little bit, you can see that the garage door is kind of falling off. There are a couple of windows that have been replaced with cardboard. The roof is covered with temporary roof patching. The fence was falling down. This was back in May. And there was overgrown plant material in the yard. I did observe that the property is not homesteaded, and I did ask for a code enforcement update. This was back in May. The second photo was taken in July and shows the condition of the property is essentially the same. I think the fence that was coming down was removed. And if you look at the property this morning, it's essentially in the same position. The accrued lien balance as of September was $662,000. The property value per the property appraiser's record is $237,000. So it's deeply underwater. the situation here is that it's going to take some extraordinary efforts to resolve this. There's a whole list of liens that are really accruing. Many of them are also of this quantity. And I invite you to step out of your normal role and look at some of these and see if the foreclosure process can't be accelerated on some of these that are really metastasizing into the neighborhood. This one, the property right next door has a crash vehicle that is inoperable next to it. And Jeff Kronschnabel, who used to be the code enforcement manager, used to say that a bad property affects 4 properties surrounding it. So thank you for your service, and I appreciate your consideration.
Thank you for bringing this to our attention, Mr. Johnson. We will look into this. I plead ignorance. I'm not familiar with the city's foreclosure process and when the liens get to be this point. But we certainly will look into it and see where the city is with this.
Thank you.
Thank you. Anyone else for items not on the agenda? Okay. Next on the agenda are the new business items. The first case, this is one we've continued from. We're getting a status update regarding Coachman Creek Condo Association at 2625 State Road 590, Building 5, in violation of code for unsafe building.
Yes, and good afternoon, members of the panel. My name is Attorney Nicholas Pisanius with the Law Office of Raven, Parker, and Gurley. I'm appearing today on behalf of the Coachman Creek Condo Association. Plan to keep my presentation here relatively short and sweet, as I've got some good news, and I hope to kick off the rest of today's meeting on a lighter note. You may recall when my colleague was here last in October that there were a couple of line items that were still delaying progress on the restoration here of Building 5, namely there were some permits that had to have been resubmitted, and there was materials for the temporary staircase that had been deferred down to South Florida. I think new materials had to be ordered, and then the engineers had to get involved and draft up new plans for those new materials. With respect to the permits, it's my understanding that they're currently in the process of being reviewed. Of course, I'll defer to Inspector Cantrell for more details on that, as I don't want to misrepresent anything. But with respect to the materials for the staircase, they have been delivered. All funding is in place, and as far as I'm aware, construction is underway. In fact, I was informed by the contractor that just yesterday the scaffolding for the temporary staircase at least was scheduled to be erected. And so the project, as we can see, has been a long time coming here. We're finally moving forward on it. I think one item that is also missing, that we're just waiting for an update on, is the electrical. The electrical vendor should be out on the property hopefully within the next few weeks. It's my understanding that they're supposed to take some readings and make sure that the setup is up to spec for certain lighting fixtures. You know, we want to make sure that during this restoration process, this is a safe and responsible project here for the residents. And so, you know, once the lighting's in place, hopefully everything else will be underway. But other than that, I would ask that we come back here, say about 3 months, possibly in April, to give a status report. The only reason I ask that is because the association is paying for our office to come to these meetings, and we'd like to allocate their funds, you know, more towards the project and not towards our attorney's fees. So, and plus, given the nature of construction in general, we're hoping that we'd have a more substantive update in the months to come.
Oh, thank you for that update. I have a question. It may or may not be relative. Wasn't there a funding issue for this from the association? Did they get?
There was, and it's my understanding that was resolved.
Does anyone have any other questions?
Yeah. Who is the contractor?
It should be Suncoast Restoration and Waterproofing.
And the electrical subcontractors?
Unfortunately, I do not have that information, but I was in contact with Karen's Engineering, who is in regular contact, and I think they're collaborating with the electrical engineers.
And the scaffolding's coming forth for the staircase?
As far as I'm aware, it was scheduled to have been erected at least yesterday. Of course, I wasn't on the property. I can't say for certain that they are in fact there, but as far as I know, they were supposed to be there.
Okay.
Mr. Kent, if there are no more questions, we'll hear from Mr. Cantrell. No more questions.
Hello, Board. Jason Cantrell, City of Clearwater. So yes, the permits were applied for. They're in queue for review. They haven't been reviewed yet. I would like to suggest that they stop on the temporary stairs until that permitting is submitted and continued. We don't want folks walking on there until that's approved. That's it. Any questions?
Is the board okay with not receiving another status update until April 2023?
Is Mr. Cantrell happy with that in April?
I think we should probably come back a little sooner just to make sure that the permit is active, and then once it's active, we could probably extend it out further for the construction.
I agree, yeah.
What do you recommend then?
I would go with 30 days again.
Okay.
Yeah, let's do that, and then you can start spacing them.
Okay.
So do we have to vote on this, or, okay, it's just a recommendation for 30 days, and then you will consider the 90?
Very good.
Thanks,
Thank you.
everyone.
Thank you.
Thanks. I know this is a long-running headache for a lot of people. Okay, case number 1-23 finds respondents FTMC LLC at 1621 Gulf to Bay Boulevard in violation of code for exterior storage. Is there anyone here to speak to this case? Mr. Casby.
Good afternoon, Board, and Happy New Year. Daniel
New Year.
Casby,
Good to
City
see you
of
again.
Clearwater Code Compliance Division. This is for 1621 Gulf to Bay Boulevard, case number 1-23. There's one violation here for Code Section 3-1502 F1 and F2 for exterior storage non-residential. These are the dates that notices were sent out in intent compliance, along with our certified mail receipt was received by the owner of the property. This is a strip mall. I think maybe everybody's seen it around the 1600 block of Gulf to Bay. I believe it's by that hobby shop. It's on the other side. In the back of the property, there's a little shed, and they store a bunch of items back there. There's a bunch of paint cans, pallets, just all sorts of manner of item not meant for outdoor use. Should have probably just been stored inside the shed,
Where?
along with a washing machine.
Did anyone see the shed?
I'm sorry, this building here is the
Oh,
shed.
that
I
is
was just
the
showing
shed.
around
Sorry.
the area. I've got better photos.
Quite a
later
large
showing.
shed, okay.
It's illustrating the dimensions. So, went back, this was all the way back in July. They're still storing paint cans on the exterior, random chunks of furniture. The washing machine was still out there in August. I had had contact previously with the owner and thought we were going to get everything settled, and then nothing ended up happening, and that's where we had to send a notice of violation. This is what the shed looks like from a far away shot. This was back in October. Looks like things are starting to be taken care of. At least the washing machine was gone. But part of the other issue with the exterior storage ordinance when it comes to non-residential properties, that when you do have a dumpster on your property, you have to throw out all your garbage in the dumpster. You cannot just pile all your garbage around your dumpster. It has to actually go inside. I went back in November, and it seemed like the same problem was still happening, that a lot of furniture was ending up around the dumpster and in the area. They were still storing all these paint cans on the side of the building. I went back on the 19th of this month, and everything was actually looking better. There was just piles of yard waste, yard debris. I was hoping that maybe they would improve from here. And when I went back today, there's more furniture around the dumpster again. So,
It's heavy.
along with a toilet. So,
It's heavy. Maybe he's waiting for a friend.
maybe. So for compliance for this property, I'm just asking to meet compliance for exterior storage by removing all items not meant for outdoor use from the grounds of the property. This includes all construction materials, metal, wood, buckets, appliances, and other miscellaneous items. All trash and refuse must be in the dumpster and not set aside it. And for compliance for 1621 Gulf to Bay Boulevard, I'm asking for compliance on or before February 25th of 2023. Or fine, 100.
Can I ask a question, Jim?
Yeah.
Do they own, is that dumpster theirs? Is there any logic or reasoning from them why they don't just put it in the dumpster?
I honestly couldn't speak to it. It could possibly be that there's a dumping issue. at the property, that perhaps outside parties are coming by and leaving items there. As far as I know, none of those properties are furniture stores, but at the same time, the property owner is still their responsibility to ensure that any garbage or debris on the property is taken care of or thrown away.
But you bring up an interesting point. If somebody else is dumping it there, did they live on the property, or is it, it's a business, or did they come there often? So if somebody's dumping it, wouldn't they have a problem? But
Well, he has
I
the
just can't
option to
understand
lock
why-
it if you.
I can't understand why there's a dumpster there and they don't put it in. But you can't answer that, so.
No, all I can do is hold the property owner responsible for just keeping the grounds of their property at least decent.
Right.
And it's been an ongoing issue for over 6 months, and I think that after having contact with them, it's nothing too much to be asking for.
I agree. Thank you.
Is this their first violation, Daniel?
No, there's always been several violations of the property, vehicles and operative vehicles being stored in the rear of the property. We had some changes with people coming and going with code compliance. I'm in a different zone. This is not even my zone anymore. This is one of my holdover cases from when I did do the downtown zone. But I've alerted the other inspectors who have taken over the downtown zone about the inoperative vehicles. They keep coming back. So it's an ongoing issue between exterior storage and inoperative vehicles.
Thank you.
Well, it looks like an easy fix. Ready to move forward on this?
Shouldn't we, have we already had a first violation?
No, we have not had.
So would this be a repeat violation then?
No,
This one is just for the exterior storage.
No, we need a first motion.
We need a first motion.
I move, go ahead. Go ahead.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
I second.
All in favor?
Aye.
And then we already have Mr. Kasman's recommendation.
So I'll move to enter an order requiring the respondent to correct the violations on or before February 25th, 2023. If the respondent does not comply by that date, the board may enter a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
I second.
All in favor?
Aye.
Motion passes. Thank you.
thank you.
Case 2-23, finds respondents Driscoll Investments 2 LLC at 3100 Gulf to Bay Boulevard in violation of code for roof maintenance. Is there anyone here to speak to this case? Mr. Kasman.
Hello again, Board. Daniel Kasman, Code Enforcement Inspector for the City of Clearwater. This is for case number 2-23 for 3100 Gulf to Bay Boulevard. There's one violation here for Code Section 3-1502 D1 and D3 for roof maintenance and clean roof. These are the dates. The notice of violation was sent out with compliance dates, the affidavit of posting, and the notice of hearing. I don't know if anybody's familiar with this property. It's the old, I believe it was an old gas station repair shop way back in the day. They've always constantly had issues with this design choice for their roof with this metal flashing along Gulf to Bay. I've been at this property several times actually since when I started with the city. This is one of my very first cases, and the property seems to change hands every few years, and the new owner tends to run the same problems with roof maintenance. This was back in October. I was in contact with the manager for the owner for the property. They were looking to sell it. I've also been in contact with the new possible buyer who said that they might have closing later on this month, but I expressed the city's feelings on this, that as long as it's in the current owner's hands, it's still their responsibility. And until the property changes hands, it's still up to them to fix it. So I've been back a few times back in November. Flashing situation's getting worse. The soffits and the fascia are failing on the sides. There's a mensch infestation by animals in there. This was my posting for our notice of hearing for today's meeting on the 13th. Back on the 19th, we were still having issues, and as of today, no action's been taken at the property to repair the roof.
I think everybody is very familiar with this highly visible property before you get on the Courtney Campbell. I've never seen it operating as anything.
I was told it was once a motorcycle repair shop.
Years ago, yeah.
There might be some environmental issues on the property that have to be resolved before it can be turned into anything usable going forward. But in its current state, it's just continued to be an eyesore year after year. compliance will be met for the roof maintenance by repairing any damage to the roof, fascia, and soffits. And for my recommendation for 3100 Gulf Bay Boulevard, I'm requesting compliance on or before February 25th, 2023, or a fine of $150 per day per violation for each day a violation continues to exist.
Any other questions for Mr. Kazman? Can I get a first motion on the violation?
I move the final respond violation of the code as referred to in the affidavit in this case.
A second.
All in favor? And since no one's here, I guess we will move on to the declaration.
All right, thank you, Board.
We still need a declaration.
I move to enter an order requiring the respondent to correct the violations on or before February 25th, 2023. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Is there a second?
Second.
All in favor? Aye. Motion passes. Thank you,
Thank you.
Mr. Kazman. Case 10-23, fines respondents INXS 7 VII LLC at 1365 Overly Street in violation of code for unsafe building. Is there anyone here to speak to this case? Mr. Cantrell, hello again.
Good afternoon, Board. Jason Cantrell, City of Clearwater. This is the property at 1365 Overly Street, case 10-23. Here we have one violation. This is an unsafe structure. I didn't type that on there, but it's an unsafe structure. Citing code section 3-1502A for property maintenance requirements and 3-1503B2 for nuisances. Notice of violation was sent on 8/18 of 2022. Compliance date was 27 days after the receipt of the notice, and that certified mail was received on 8/30/22. I did get no other contact from the owners other than that they signed for the green card. So a notice of hearing was sent on 10/12/22, and I did an affidavit of posting the same day. This property is on Overly Street. It is between Kings Highway and Betty Lane, a little north of Palmetto Street. Okay, so here it is pretty extreme settling that's going on at this property. Could possibly be a subsidence, I'm not sure. But what you're looking at here is cracks over the lintel above the door. That lintel does support all of the weight of the structure that's above that door, or it's supposed to. That's the same door that's down at the bottom right corner. You could see the cracking there as well. Here is another window. Notice above, the lintel is in bad shape, cracked through there as well. And this window is in the carport, same issue, cracking at the lintel. This is the back of the house. You can see there's cracking everywhere. As you look down closer to the bottom, it kind of looks like the first and second course of the concrete blocks have shifted. That is the window right above that area. You can see cracking through that left corner of the window lintel there.
Is this a residence?
It is, and it was tenant occupied. I don't believe they're in there now, but it was. This is, I believe, the same window that's just showing a little bit of spalling of the concrete right there. Now we move to the interior. It's a little indicative of something more serious going on when you start seeing the same thing going on the inside. So you see the cracking there. More above the window. This is the ceiling above that window, cracks in the ceiling.
Did someone report this violation?
That was my question.
Yes,
How did
the
this
tenant
go?
did.
Oh,
Is that how you got in?
It is, yes. And actually, the tenant quit paying rent because they were non-responsive to the issue. Again, crack in the ceiling. You can see the crack continued down the wall, and at some point they tried to patch over it and hide the problem. More issues on the ceiling, more cracking. You can see on the left bottom corner there, it looks like some water intrusion. There's a better picture of water intrusion. This is actually a different area than the last photo, but more of the repairs you see on that side there. Coming down the kitchen wall, the ceiling, the crack all the way down the wall, they attempted to cover that up again as well. This is in one of the bedrooms. And that's it.
Aside from the water damage, with the cracking, obviously you can see it's substantial, but how do you determine between normal settlement and cracking versus a structural defect?
We wouldn't determine that. I'm not an engineer, so we required a structural engineer to come out and evaluate.
And has that happened or no?
It has not happened.
Would that be something you would do or the owner would be
The
responsible?
owner has to do that.
Okay,
I can tell you right now, those are very old cracks. They're not new.
yes.
So is it fair for us to vote as this is a,
For what it's worth, when the house sold to the current owner, it was listed as having a sinkhole that was repaired. However, I didn't see any
You would
permitting
find
on file for
documents.
it.
Okay.
That would have a lot to do
And
with
you
it.
would have an engineering report or something. Okay, so let's do a motion. I move to find the respondent in violation of the code as referred to in the affidavit in this case.
A second.
all in favor?
And then, so your recommendations?
For compliance to be met for the unsafe structure, have the property evaluated by a structural engineer, provide the city with that report, apply for, obtain, and complete any required permitting and repairs. Our recommendation would be to provide the city with the engineer's report by February 25th, 2023. Obtain any required permitting by April 25th, 2023. And that engineer will let them know what repairs are going to need to be done. And finally, complete the permitting and repairs by June 25th, 2023. Or a fine of $150 per day that the violation continues to exist, and any reasonable cost be applied as liens against the property. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
And you have spoken with the owner?
I have not.
Oh, just that they received the
Correct.
notice in August?
Correct.
Is that February 25th timeline for the city engineer, is that enough time for them to call the engineering department and get them over there? or
They're
what?
gonna have to
It-
get a
it is,
I can
private.
hire a structural engineer and they should be able to get out there within a month. It's only about maybe $500, $600.
They should be able to, but again, they've had since August, so.
Yeah.
It's not occupied.
I believe the tenant left.
Are we under any responsibility to make sure that it's not occupied? I mean, is this something that
This is
you
just
might
gonna turn into
use
a
the
meeting.
word condemn? Or
I will defer that to legal. I don't think
At this time, we don't have enough information for that, and it's ultimately the responsibility of the owner of the property to keep and repair their property to the adequate standards. So, at this point, I don't see any need for that.
So if something really bad happened there, we wouldn't be liable, the city, I
I
mean.
mean, I can't say, I don't know what really bad would be. There's a million different scenarios, so I can't say that with 100% certainty, but at this point, that level of cracking and what's occurring in that property, as someone else stated, looks older, so we, who knows when and if, but we can't prevent every property in the city.
I just don't like the idea of requiring a homeowner to get an engineering report just because their tenant says the building is unsafe. That's where my concern, might be a little bit of overreach. I don't know.
Good point.
But surely the owner has to know about it as well, regardless
It
of
looks
who
like
rents it.
it looks like half the buildings in old
But
houses
he's
in Clearwater.
responsible for
It
the
doesn't
safety
matter
of the
who rents it,
structure,
it's
and
the
if
owner's
he's,
responsible.
whether he's living in it or renting it, he's still responsible for it being structurally sound.
Yeah.
I mean, I would think it'd be $500 well spent to know if it is or it isn't.
I agree.
Well, Yeah, but, so if that report says you need to have your whole house leveled, then we're slapping on the permit on top of it. It's not just the engineering report, this is voting on, then you have to have the permit, then you have to have the repairs.
Yeah, because if the report comes back and says there is indeed structural damage, then that's gonna have to be addressed. I mean, that's part of home ownership, whether
Well, if he
it's,
doesn't have anyone in it, I mean.
well, isn't what we're here for is for structural, is for safety around the community, like all the properties, to make sure that they're safe and sound? We can't guarantee he's not gonna rent it to somebody else. What if a new family moves in there and then it is not structurally sound? I mean, I get the whole idea of not being overreach, I agree with you on that, but at the same time, part of our responsibility is to make sure that we hear what they're saying and making sure that it is.
I don't believe it's overreach at all. I think we won't know anything until you get that evaluation.
I mean, the report could come back and say it's fine, it's just, needs to be repainted, or, there's a leak at the roof, so it's causing other damages, We don't know, we're not the experts in that, neither is he.
Good scenario would be, just because nobody's living in the house now, there are neighborhood kids that go where neighborhood kids go, and if something were to happen and a wall would fall or the ground opens up or anything,
Yeah.
that could be an issue.
I mean, it's the same thing as like having an empty pool. You can't just have an empty pool sitting there, because heaven forbid the neighbor gets in there and...
Could I make a comment? If we impose this violation, it would seem to me that it's going to kick these people into gear to do something. And if they come back in a month and give us some legitimate excuses or things that they're doing, maybe not getting an engineer or have some legitimate idea, we can then resolve the issue then. So all we're doing here is saying, get it done. And then if they finally move and come back and present a good case, then we can resolve the issue. At least just kicks them in the butt, and use the word, and gets them going.
The engineer's not going to provide any kind of permit until he inspects it.
Yeah.
Then he'll tell you what kind of permit, either tear it down or it can be repaired. It all dwells on him. I agree, that's the first step.
Or it could be nothing. It could
Well, there's going to be something, you can see that.
I think so too, from my experience,
Well,
having dealt with it. I mean, it's a 3-2 usually. I mean, one case, there was not, in my experience, one where there was nothing was required other than monitoring, because it was minuscule. On the other hand, I have had situations where they have had to come in and have some structural integrity done to the home. But we don't know at this point, and like you said, it does look old, I agree. So the best thing to do is to have a structural engineer come out and look at it. And he would then decide, does it need more, he or she decide whether something more needs to happen to it, or if it needs monitoring, or...
I don't want to toot my own horn.
I don't think they'll all have the same opinion
Wait just a
either.
minute, I'm not finished. I don't want to toot my own horn here. One reason I'm on this board, I was a structural engineer.
So you should know.
I know
Yeah.
what has to be done, and I'm telling you, that's what needs to be done, period.
So even more,
That's the first
well, you're
step.
justifying it even more that we do need to have
Yeah.
that done.
And those cracks, he's going to see all those. Those aren't new,
Yeah.
and he's going to take the proper procedure.
I agree. I agree with everything you're saying.
All right, well, may I have a
Anybody
motion?
else? So we did the first motion, so is everyone okay with what he's requiring in this timeline?
I'm good with it. I'm good.
All right, I move to enter an order requiring the respondent to correct the violations on or before February 25th, any required permits by April 25th, 2023, and if work is required, to obtain the permitting and repairs by June 25th of 2023. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Was that the unsafe,
This is the unsafe, 10-23.
that would, but, okay, just checking that was the correct version, sorry.
Yeah, unsafe building, yeah.
Is there a second?
Second.
All in favor?
Aye.
Motion passes. Thank you, Mr.
Thank you.
Cantrell. And that is all for the new business items. Unfinished business, we're accepting the affidavits of compliance, which we can accept all these at once. Case 49-22, case 84-22, case 105-22, case 110-22, case 111-22, case 115-22, and case 116-22, all affidavits of compliance. May I have a motion to accept them?
I'll make a motion that we accept the affidavits of compliance listed by the chairperson, excuse me.
I second.
All in favor?
Aye.
Okay. Is there anyone here to speak to the affidavits of non-compliance? Case 52-22, Elia Ronchetti at 20 Logan Street. Case 74-22, 1472 Pierce Street. Case 79-22, 1400 Cleveland. 91-22 at 924 Mandalay. Or case 92-22, BTH Residential, Craig Ball at Browning Street.
Oh, yeah, let's see who they-
Oh, Mary, your case 91-22, correct?
I'm 22 Jones.
Come on up. And tell us your name and address.
Mary Margaret Jones, 924 Mandalay Avenue, Clearwater, 33767. On this, I had submitted the application for the permit last Thursday, January 25th, and they're mowing through that right now. It looks pretty good.
Last Thursday,
Last Thursday.
the 8th.
The 20, wait, when was that?
Last Thursday, 7 days ago, you applied for the
Yeah,
permit.
right.
Okay. The 18th, okay. Go ahead.
There was a real delay with this engineer. He's really particular and kind of reminds me of Spock from Star Trek. I mean, he's just like, he doesn't care about, he can't be pushed. He was just very methodical, and there was a delay there, but I have total trust in him. It's very thorough.
This was regarding the fire, correct?
Right.
Fire.
Garage, yeah.
And we're repairing the building. We have the roof permit in, but depending on what they decide overall, they'll finally decide that. We went ahead and tried to have a few electrical outlets added, so I'm working for that as well. I'm trying, since it was put in so late, and I think today is the deadline, the permit be approved. I think today might be the deadline, or I'm not sure.
Today's the deadline for your affidavit of non-compliance.
Yeah. So, got my permit in, they're working on that, and I'm trying to get as much time as I possibly can for them to process that, and then we have crews lined up to finish the work, so.
So you intend to have the structure repaired and then the roof over the structure repaired
Yes.
and everything, okay.
And so the permit's been submitted,
I don't think it's been approved, I think it's.
but it hasn't been
in
approved,
process.
right? And
It's been applied for.
Right, so I'm certain that the permitting people will need at least 10 days, 15 days.
Board, I believe the compliance date has passed.
Yeah.
To have it
If,
approved.
can I just get a quick update from Mr. Cantrell, and then we'll call you back up if we need to, Ms. Jones?
Yes,
Is that okay?
yes.
Hello.
Good afternoon. So, yes, she did apply for the permit last week on the 25th, and it's in for review. The reviews have not begun yet.
Is it two separate permits, one for the roof, one for the structure?
She does have two permits in there, but the permit for the roof will not be approved. The structure's gonna have to be rebuilt, which is what the second permit is for. So the first permit's going to be, need to be voided out.
Would make sense. And so she does have the second one applied for?
Yes,
Okay. As a homeowner or the contractor?
homeowner.
Okay.
So how long will it take for her to get a permit?
It depends on what kind of conditions are found, but it could take a couple of weeks.
And when was the fire again?
I don't recall. I think it was last September, maybe?
Yeah, we have been looking at this for a long time.
It was June, it was last summer.
It was a year ago.
But there's good faith effort in pushing things forward. Everything seems to be going well.
Yes, she did apply for it
So,
This week.
thank you.
this week.
Board, we are past the date of the original compliance date. And that's what we're hearing.
Correct.
Property owner is not in compliance.
Because she doesn't have a permit, correct?
Because she hasn't made
Board,
any
for your
efforts last
reference,
week.
this case was heard in September of last year, and the order was obtain the permit by November 28th and complete the permit by February 8th. So that was the order of the board back in September.
And every time she's come back, she's asked for extra time to get that permit, so we're still in the same place.
Can I add,
Certainly.
with the hurricanes that have happened, I've had.
Hold on, just come up to the mic and speak,
Oh.
because, yeah, or else we
With the hurricanes that have happened, it's been like pulling teeth to find a structural engineer. You just call them. In fact, I got several names from the building department. Wazalewski, and they're just like, I don't know why you're calling me. We're really booked up. You'll have to wait. We're months backed up. So I finally got one. So that's been, there's been 2 or 3 hurricanes and storms, and they all went down at Fort Myers. So I've been on the phone.
Wasn't there an
Screening
issue
them.
with the insurance as well?
No, I didn't have insurance. This is all out of pocket.
Okay. Understood.
I was in between insurances, so it's all on me.
So the question is, do we want to give her additional time or not, correct?
So board,
The question is if we want to accept this or not.
instead of extending a timeline, you could continue this affidavit of non-compliance to the next meeting. But there's no opportunity here to give additional time. That would be your avenue.
The purpose of this hearing for this today is either to accept or reject the affidavit. So you can continue it or you could reject it or accept it. Those are your options.
Continue, reject, or accept? I think she's making a good effort to make the property correct. She doesn't have insurance. She's doing it out of pocket. There certainly is a legitimate excuse with the hurricane and all the issues that were going on with that. It may have been taking a long time, but we're not here to hinder people who are trying to do the work. It may take a little longer than we expect, but I'm for extending it. I've been
Kind of
Thank you.
on the opposite.
Board members have seen the pictures.
We have. And we
I
heard
haven't.
we also heard from the neighbors regarding this property at the last meeting.
Correct, so we have 1 board member that has not.
Yeah, I'm new. I'm new today, so.
Jason,
Dana, I'm sorry, I turned the mic on, but I don't think it's on. If you could come, either press the button or come to the podium. I'm sorry.
I had a real issue with the neighbor. He had a long history of harassing me. Mr. Al, next door, he came up here and told basically 10 lies right in a row. Didn't understand why I dared to have homestead on my property, that he said I hadn't paid my taxes in years. I'm up to date on my property taxes. There's nothing wrong. He has some kind of issues. He's been trying to blow up his phone and send emails behind the scenes all this time to hope. His goal is to hopefully influence the engineers in the city to deny my permit, which is not cool. And I know Mr. Root would not fall for anything like that. But don't let Mr. Hunsberger influence anything you decide today.
Thank you, Ms. Jones.
Because it's hard to do, it's very sad to have a bad neighbor, but you still have to have compassion for him because he obviously has some sort of terrible issues to want to slander an old lady next door. So, I don't know. Don't let that come into play.
Well, the board appreciates the steps that you're taking, and this case has been dragging on for a very long time. Are there any more questions for Ms. Jones? Anything else, Mr. Crenshaw?
I appreciate you,
Thank you.
all the work you've done on helping me.
Thank you.
If I can run through the photos for Mr. Schultz real quick. Sure. Appreciate that. So this is the garage that caught on fire. It's in pretty bad shape. That's the roof decking. Some of the plumbing on the walls. That's it.
Well, if it was my neighbor that had that, I'd be upset as well, but I can't, I still say that it sounds like the owner is trying to make a good faith effort in doing it. I realize it's been going a long time, but again, I still stand by the fact that I think we need to give them more time.
Okay. If there are no more comments, can I have a motion? I can't make the motion. You have to make, somebody has to make the motion.
To continue?
No, to either accept or reject with the continuance?
Just a proposed motion from anyone, whatever anyone's choice is.
Well, I think we need to see where we're, I mean, I'm okay with continuing it one more month, but not beyond that.
You can motion.
I'll make a motion that we continue.
Thank you.
I'll second.
Oh, you're not going to read it?
I don't know where's that?
Oh, you just wait.
I don't hear.
Are you second?
Yes, I
All in
second.
favor?
Aye.
Nay.
I'm making sure I'm here next month.
Okay.
Thank you.
Motion affidavit is.
Oh, we need the
no.
affidavit and outcome, so we can group accept the rest, right?
And there's no one here from 92-2, correct, Browning Street?
Okay, that's fine. That's fine.
The rest.
Not the peonies.
So do you want to lump, and can I get a motion to accept the
Yeah.
rest? Oh, I'm sorry.
Oh, I'm sorry, actually, no. Give me the two case numbers. I apologize, thank you. Board, just so you all know, we have been reviewing some policies and procedures of the Code Enforcement Board, so we're making a few changes. And so this is going to be one of the first ones on case 52-22 and 92-22. These are short-term rental, residential business tax cases. So in those particular cases, you all have heard before that the residential business tax costs
$31.50.
a year. So in the assessment of those fines, we believe that $150 a day for that is not reasonable. So we are requesting that you all amend your order to be $50 a day instead of the $150 a day. And going forward, that's what we're going to be requesting on these types of cases.
Okay.
So if you are willing to amend your order, we'd ask that you make a motion to amend that order and then to approve the affidavit for the amended fine amount.
I know that with these BTRs for the short-term rentals, we've had this issue come up in the past about the fines per day being less than what they're actually renting these spaces for.
Ma'am, Daniel Kasman, Code Enforcement Inspector. This is not for short-term rentals. It's for just getting a residential rental business tax receipt. These are for normal rentals, legal rentals.
It's like
31
year-long
days or longer.
rentals,
Oh, okay.
those types of, I misspoke, I apologize.
Okay.
So I can make a motion just to amend those two,
Yes,
and then we can lump all of them to accept the affidavits and outcome.
yes.
Okay. So I make a motion for case 52-22 and case 92-22 to amend our recommendations to $50 per day for each violation each day it continues to exist. All other terms remain the same?
Yes.
Is that from memory?
I'll second that
Second.
motion.
Thank you.
All in favor?
Aye. So now for case 52-22, case 74-22, case 79-22, case 92-22, I move to accept the affidavit of noncompliance and issue an order that imposes fines and states If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
I hope I did that right. Okay.
That was very good. Okay. Oh, election of officers.
Lord, it's that time of year. So annually in January, the first meeting of the year, the board elects a chair and a vice chair. You can nominate each other, even if the people aren't here, they can be nominated.
So I can nominate him to be chair?
Now, I did speak to Mr. Farrar earlier, via email earlier today. He did express interest in the vice chair position if there were no other nominations.
He's trying to make you queen.
I don't want to. I'm okay being vice chair. I'm not interested in being chair.
It's gonna
So
be
if
an arm
anybody
wrestling
else would
match.
like to step up,
Need a chair.
are you going to continue?
Jeez,
Put that on
that's
there.
a bunch of weenies up here. Come on.
I nominate this gentleman to be chair.
Which one, Mr. Brown?
Yes.
I second it.
You have enough commitment,
Yeah.
schedule-wise?
Yeah, I think so, yeah.
So all in favor?
All in favor? Is he
Aye.
in favor?
Aye.
All in favor?
Aye.
Aye.
So then we can make Mr. Farr the vice chair?
If that is.
I nominate Mr. Farr to be vice chair.
I second. Can I second? All in favor?
Aye.
Aye. Motion passes.
Sweet.
Thank you.
Thank you. Okay, nuisance abatement lien filing. Case 5-23, accept the nuisance abatement lien filing for respondent Sean Morrissey at 1389 Browning Street. Is there anyone here to speak to this
Doesn't look like it.
filing?
Right.
If that's the case,
I would like to present the case
Oh.
board for this one.
by all means.
Daniel Casman, Code Enforcement Inspector for the City of Clearwater Code Compliance. This is for 1389 Browning Street. Case number 5-23 is for a nuisance abatement. There are two violations here for Code Section 3-1503 B5A and B7 for accumulation and placements of nuisances and lot clearing violation, along with Code Section 3-1503 B6 for an operative vehicle. These are the dates of notice of violation and compliance date with the affidavit of posting. This was brought forth as a complaint by a neighbor. There was a large amount of items in the driveway and behind that fence there, outdoor nature, just bins, boxes. And this car in the front yard here has been brought forth about this property twice by my predecessors, Yusuf Touré and Vicky Shedeth. It keeps coming back. I did speak with the person at the property responsible for this. Apparently there's a Tracy Cross who lives at the property. And these are her items that she keeps outdoors, and this is her vehicle. She keeps bringing back to the property every time, just posted by a code enforcement member. This was in December. I had been in contact with her, and she told me she was going to clean up the property. And she did good by her word, and when I went back on the 23rd, a few days ago, there was just still some items left. And when I came back today on the 25th, everything's been removed, and the car is no longer there. My only concern is that the car continues to come back over and over. So I just like the board order to still proceed ahead, so I have something just in case the car comes back at the property.
Okay, any other questions?
So just coincidence, the car disappeared today.
Well, as I explained it to Ms. Cross, I'd just like to have some insurance that the car is not going to come back, and I'd be more than happy if she has the car on the property with the license plate and current tag.
It was there yesterday, but it's gone today. Okay.
Right, and through the work of two other prior code inspectors who have worked in the same exact vehicle, I would just like to have that assurance that it's not going to come back.
Maybe
It'll
there's
probably show up
magic.
tomorrow.
Does the city pay you for having this much fun?
Yes, they do.
Okay, does the board have any other comments, or may I have a motion?
It's just the nuisance abatement one, right?
Yeah.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with a reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Motion passes.
Thank you very much, Board.
Thank you. Case
Thank you, Dan.
6-23, nuisance abatement lien for respondents Devom 2 LLC at 20162 US Highway 19 for transient activity. Is there anyone here for this case? Hello, Mr. Jensen.
Hi, I'm Dave Jensen, Code Inspector with the City of Clearwater. We're here for two, grab the wrong one? I'm off to a great start with you guys.
We knew you weren't Daniel.
And
I
while you
was
pull
just-
that up, Board, just so you know, this was another one of the changes that we actually go through the PNU cases, so that if someone were to have their property abated at a later date, they can come back and watch what it was that was alleged against them. So that's why we're going through these cases going forward.
I actually don't see mine on here. Am I missing it?
Right there.
Ah,
That's why I always put the address in front.
thank you, sir.
You're welcome.
I was a little flustered by the fact that I didn't realize we got paid for doing what we're doing.
You're in good
Oh,
company.
no, that's supposed to start. I'm sorry. Dave Jensen, I'm with the City of Clearwater Code Compliance Inspector. This is for 20162 Highway 19. It's case number 0623.
Dave, this is- oh,
sorry?
There's a little button on the bottom.
Oh, sorry. Just start.
There you go.
Dave, this is Mr. Jensen's first presentation.
I know.
Welcome.
Probably my last, too. Violation of Code Section 3-1503 B5A for accumulation of trash and debris. These are the dates that the mailings and the violations took place. The return receipt was received on the 19th. It's the roadway in on Highway 19. The accumulation of debris is the result of a homeless encampment that was there. On the original date, there was a homeless encampment with bedding material and stuff, which has since been removed. However, there's still a bunch of debris that was there. The original date, I spoke to the manager and the owner, both explained to them that further down the fence line from where just the encampment was at, there was a lot of other stuff that was going to have to be cleaned up. The shopping carts that were there on the date, you can see the bedding in the background. Those have been removed. However, when I was doing an inspection, I saw the person doing the cleaning taking the shopping carts down the sidewalk to an adjacent property that is not theirs. I had to address that with the folks at the hotel. She made them bring them back and get rid of them instead of just dumping them on some neighbor's property. Those have been taken care of. However, this is looking from the north to the south. All of that stuff is still there. This is from the date of the violation, and this is a picture I just took.
I'm sorry to interrupt. This address is a hotel?
Yeah,
Okay.
yep. And so these two pictures, this was from the date of the posting, and then this is the same exact view from yesterday. All the stuff is still there, it's just overgrown with weeds now. So what's left of some sort of beach chairs just showing up in the last couple of days as well. The shopping cart's the same what's been there. So we're asking to have the items removed, discarded, all the trash to be cleaned up from the property. And as I said, I have spoken to the actual property owner about it. Part of it was cleaned up, just a lot of the other stuff was just left there. So requesting compliance 5 days after the board renders its order.
It doesn't seem too complicated for her to maintain that. Okay. Any other questions, comments? We have a motion.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with a reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
A second.
All in favor?
Aye.
Aye.
Thank you.
Thank you, Mr. Jensen. Case 7-23, accept the nuisance abatement lien for
Good job
respondent
there, Dave.
Aaron and Katrina Mack at 1625 North Washington Avenue for inoperative vehicle and lot clearing. Is there anyone here to speak to this? Hello, Mr. Dixon.
Good afternoon, Board. Inspector Dixon for 1625 North Washington Avenue. This is case 07-23. There are two violations at this property. One that's violating Code Section 3-1503B7 and B5A for lot clearing and accumulation of placements and nuisances, and Code Section 3-1503B6 for inoperable vehicles. Notice of violation was sent and posted on the 14th of December with a compliance date 10 days later, and they did sign for the mail. This is a vehicle that's got flat tires. It's full of debris and garbage. The plate's 2 years old. And there's a lot of debris that's maybe spilled out of the vehicle. This is a little later on. They did start cleaning up, but the vehicle still has the same expired tag and flat tires. It's just less debris. And then
Is that sign directed at you?
could be. This is today. The vehicle's still in the same condition, and different items around the vehicle. So compliance can be met for the inoperable vehicle by removing the vehicle from the property, or the vehicle must be roadworthy and display a current registration if they're going to keep it on the property. Compliance can be met for lot clearing by removing all trash, debris, scrap, and spare tires from the property and clearing all overgrown vegetation. My recommendation for this case is request compliance 5 days after the board renders its order. If compliance is not met, request an order be issued allowing the city to take all reasonable actions, including entry into the property to abate and maintain the nuisance and charge the respondent with a reasonable cost, which will become a lien on the property.
Any other questions for Mr. Dixon? We have a motion.
I move to enter an order finding the respondent in violation of the code and requiring the respondent to correct the violation within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain a nuisance and charge the respondent with a reasonable cost which will become a lien on the property. If costs and fines and fees remain unpaid for 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
A second.
All in favor?
Aye.
Aye. Motion passes. Thank you, Mr. Dixon. And the last one of the abatement lien, case 8-23 for respondents Brian Dreggers at 1345 Browning Street for inoperative vehicle. Is there anyone here to speak to this? Hello, Mr. Smith.
Hello again, Board. Daniel Casman for the Code Enforcement Inspector for the City of Clearwater for 1345 Browning Street, case number 8-23. This is a nuisance abatement. There's one violation here for Code Section 3-1503B6 for an operative vehicle. Notice of violation was sent out in January this month, with the compliance date the 14th of this month, and affidavit of posting was the same day as the notice was posted on the vehicle. I have a history with this property and this vehicle in particular. It's a Pontiac Bonneville with a plate that's been expired since 2016. I was originally brought out this property as a complaint back in July of last year. I had spoken with the owner, tried to explain the situation. He said he was looking to get the vehicle registered. I had originally posted it back in August. I had given him more time for the vehicle, had to post it again in October, but at that time it was going to go to Code Board, but he ended up removing the vehicle from the property, so there was no further issue. As I was driving by again on the 9th of January this year, I saw the vehicle had returned, and I heard he had some issues with the fence of the property, and as I went around the vehicle, I noticed that it no longer still again has no tag on the vehicle. So I posted again for today's hearing. I went back on the 17th after the compliance date. There is a tag on the vehicle, but unfortunately, I don't know if you can tell the difference. I don't know if you guys can see that's at least 6 characters there for that tag, and the license plate only has 5 characters. And when running a David report on the vehicle, it is still hasn't had its registration renewed since 2016.
Stolen sticker.
I went back on the 23rd, the same issue. This tag does not belong to the vehicle, and I went back today, and he's still running the same tag on the vehicle. So, compliance will be met for the operative vehicle by obtaining a current tag on the license plate that belongs to the vehicle. Using another vehicle's tag does not satisfy the ordinance. So, I'm requesting compliance on it before 5 days from the date the board renders its order.
Well, when you look at that the little decal thing, can you look up who or what vehicle that actually belongs to?
Let's see. I tried, but I tried once, but I wasn't going to try to continue to waste resources guessing what it says. My guess was 1GAKYA. I don't know if anyone else has a different conclusion there.
It's crazy.
Looks like he went through and maybe marked with a black marker to make it look newer than what it was in that last picture as compared to that one.
It could possibly be.
Yeah, it looks bogus, yeah.
Yeah. I'm just asking that he just gets a current tag on the vehicle, or he's just got to store it somewhere else if he can't get it registered.
Understood. Any other questions for Mr. Kasman? All right, may I have a motion? Oh, did you give your recommendations? I'm sorry.
I just requesting compliance on it before 5 days from the date the board renders its order.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with the reasonable cost which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Aye. Okay, thank you guys. Is there any more business to come before the board? If that is the case, the board is adjourned. That's it.